rise. The court of appeals division 1 is now in session.
Please be seated. Good morning. We're here in our case, one's CV23-0021, IVEY officer's turning point. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you want for rebuttal, but you'll have to keep track of the time yourself. That's why we have a clock at the podium. We are recording the argument both in audio and video, so when it's your turn, please identify yourself and your client for the record. So if we listen to it by audio only, we can keep track of who's who. The video will be on YouTube in a couple of days, so you'll be able to judge for yourselves how well you think you did. We've read the briefs and conference the case that we understand and are familiar with the facts and the issues. So when you begin your argument, just start right out with what you want to talk with us about. Counsel, you may begin.
Your Honors, do you prefer that we be at the podium?
Yes, please.
My name is Jeff Coughlin, and I represent the appellants, the IVEYs. I understand that you all have read the briefs, and I can only assume that the references to the record you've read as well as the summary judgments and the statement of facts and all the layers of things that you have to go through. So I'd like to highlight some of those things. I don't want to repeat them. I couldn't possibly do it in 20 minutes. Basically, Turning Point was the general contractor for the owner of the property. Despite the comments that have been made by the appellee, was not the construction manager. He testified under oath in court that he was the general contractor for the project. And that project was the building of a residential structure right on the precipice of a dramatic fall off of earth that it was really the only place they could build it at that level. And they built it too close to my client's property. And in fact, they paved my client's property. They put a series of pavers down on the IVEY's property, and
let me just
they had no
clarify,
right to do that.
before they did that, they removed, was it decorative gravel? Is that what was there?
Yes, there are two easements that access my client's property. One is a asphalt paved street that the developer put in, and on the Turning Point, let's say for identification purposes, on the Turning Point side, there's a landscape easement that contains that decorative rock. And Turning Point removed all of the decorative rock, excavated it to get the construction going on the building, and didn't replace it.
Were they allowed to go that far to remove the decorative rocks?
I'm sorry, I didn't...
Were they allowed to do what they did as far as removing the decorative rocks?
No, I mean the decorative rock was on my client's land, and it was a landscape easement that was in pristine condition. They went in and they removed everything. They had absolutely no right to touch it.
Did your client object and say,
absolutely.
Wait a minute.
Yes, immediately. And in the trial court, there were photographs that showed the pictures of it before, the pictures of it after Turning Point removed all the material, and ultimately the leader or the owner of Turning Point, James Turner, promised, he said, don't worry, I understand your concern, we'll put it all back. Well, they didn't. They put a portion of the decorative rock back, but then they built a driveway out of pavers on my client's property. So,
Is it clear from the record why they did that?
no, they felt that they could. They felt that it was approved by the city, but the city defers to, even on a general plat, to CC&Rs that control how a property is developed, and it was not allowed by the city, and it was not allowed by the CC&Rs. But we didn't allege a CC&R violation against Turning Point.
What is the basis for your nuisance claim? I understand your clients don't want the pavers there, but how do the pavers prevent them from using their property?
Because it is now the owner's driveway. So if my clients wanted to use it, they couldn't park on that driveway. Their mail service can't do a circular turn and cross over that property. They'd be crossing onto the current residents, owners, part of that driveway.
Well, are you saying the pavers prevent them from using their own driveway?
My client's driveway?
Yes.
No. But it's my client's property.
Okay, but what's the basis for the nuisance claim?
The nuisance claim was, as soon as it happened, and it was a complaint that my clients made directly to Mr. Turner, this is a nuisance for any of our use. And also, actually, the CC&Rs, although I will concede that the Turning Point is not subject to the CC&Rs because they're not an owner, they're not the developer, but they're the agent of the owner, and the CC&Rs define any violation of the CC&Rs by definition a nuisance. So the violation was that the driveway was not according to the setback requirements, built according to those requirements, and so they had to have 20 feet from the garage door to the right-of-way. Well, there's no right-of-way. It's my client's property, so they have 12 feet. The remainder is on my client's property, and you just, based on the record, if you see what the response to the summary judgment was, these people, Mr. Turner and the other defendants in the case, felt like that roadway was a city street. It wasn't. It's my client's property. It was initially placed there by the developer.
Has your client been prevented from the use and enjoyment of their property?
Yes.
Okay, how?
They were prevented during the construction because that's where everybody parked, on my client's right there on my client's property. Every day they had to come in and out and try to get around their trucks. That's over. It's built.
So what about now? Is there anything preventing them from using and enjoying their property?
No.
So what is the act of nuisance?
Well, I've briefed it. I didn't expect we'd be talking about the nuisance and the nature of it, except for the fact that it was built and it created a nuisance because it was in basically a taking of my client's property, and they altered the flow of water. They altered the flow of the slopes. There's a drainage easement. All of that is a nuisance. In the event anything has to be done to correct, like a flooding issue or an electrical public utility issue, those pavers have to be removed to get to that area. So that's in itself a nuisance.
And what is the basis for your claim for declaratory relief?
No different than I've stated in the brief.
Well, I was hoping you could clarify what you've stated in the brief.
Okay, well, I can.
I mean, what is it that you want to have declared?
Well, that the rights between the parties, which the judge in the trial court was not willing to do.
And what are those rights you want declared?
That Turning Point essentially made a promise to restore the land to its original condition and did not. My clients relied on that promise. When they saw that things were not going according to what that promise was, they sent two letters to all of the parties involved, the general contractor, Turning Point, Captiva, the owner and the new owner, Stewart.
Counsel, if I could maybe direct you a little bit there. This
Sure.
is, I understand the summary you're giving of a chronological factual scenario, but I think what maybe Judge Kiley and Judge Howe were getting at is, can you distill down for us when you say you wanted the court to declare the rights between the parties, maybe think of it as bullet points. What are the rights between the parties that you would like, if you were writing the order, the declaratory order, declare what?
Okay. That the Iveys have the right to keep their own property, not have a X number of square feet of pavers that don't belong to them encroaching on their property and being used by their next door neighbor every single day. And I mean, that's primarily the issue. But in addition to that, this driveway that they've superimposed on my client's property doesn't comply with the plat and the CC&Rs in that they were required to have a driveway that allows the parking of two vehicles back to back. They can't possibly do it. And the judge, in the remainder of the case, ordered them not to park in that space, the new owners, because why? Because the pavers are on my client's property, so they can't comply with that part of the CC&Rs, the plat, and so there's a contradiction. It's okay to leave the pavers there, but you can't park on them because they're on my client's property. So I don't know if that helps what you're asking. Okay. All right, there's an issue that the appellees make that that somehow I've argued that the CC&Rs apply to Turning Point. In my complaint, under the breach of contract count, there were multiple counts, but the breach of contract count that was alleged towards Captiva and the Stewarts alleged that they were both bound by the CC&Rs. That does not include Turning Point. On page 8 and 9 of the second amended verified complaint, it includes only Captiva and Stewarts. So this is the basis of 2 points. One is that there was no contractual issue, and the second is the attorney's fees component, because they applied for and were granted attorney's fees under ARS 12-341.1, when in fact I never made any allegations on the basis of a breach of contract claim, which I did against the others. So that the imposition of those fees was not justified. Another issue was the appellee's claim that for the first time the Iveys brought up the issue of damages related to lateral soils. I think their statement was on page 14 of their brief. Furthermore, the claim surrounding the lateral support soils is something that appeared for the first time within the response to the motion for summary judgment. That's incorrect. I have Exhibit B attached to my response to the brief. Exhibit B is a supplemental disclosure statement that was dated months and months before the summary judgment proceedings. Then finally, the attorney's fees. There are two bases for attorney's fees alleged and granted by the trial court. One was statutory in terms of 12-341.01, and the other one was the sanctions fees. And I think I've briefed sufficiently what the basis of my objection to that is, but essentially the judge didn't consider any of the factors that are required under 12-349, and I believe that the Iveys were entitled to that analysis and would ask that the court overturn that, and would ask that the court overturn the fees under 12-341 because they did not arise out of a contractual breach alleged by the plaintiffs against Turning Point. Yes, it was alleged against other defendants, but not Turning Point. That's all I have.
Thank you, counsel. Counsel?
Thank you. My name's Taylor Nelson. I'm counsel for Turning Point Homes and Development Incorporated. Thank you for the court for allowing me this opportunity to speak. On behalf of the appellees, Mr. Coughlin, I see you again. There's two main points I guess I want to address directly. One is the agency component of Turning Point, actually what their role is overall in this case. The underlying complaint alleges claims against several different defendants, and so as counsel pointed out, some allege at certain parties and not alleged at the others, but Turning Point is not a general contractor. Paragraph 2 in their motion for summary judgment states that. That was one of the issues before the court. The court didn't find that they were bound in any way as a general contractor.
We do have to interpret the record in the light most favorable to the non-moving party, correct?
Yes.
There's evidence that would support a finding that Turning Point was the general contractor, right?
I don't think that there would be. There's allegations that they might have been a general contractor, but they didn't pull permits, they didn't do surveys, they didn't do...
Didn't Mr. Turner testify at the evidentiary hearing, I'm a general contractor?
He's a general contractor. By profession, he was not a general contractor on this job.
Okay, and wasn't he asked about employees working on the job, and he said, we have no employees, and so the question was asked, so it's entirely you, the general contractor, managing subcontractors, correct? And he answered, correct.
He did answer correct.
So from that, one could assume that he was the general contractor on this project, right?
Well, my argument would be that he was addressing it, he was not addressing that question in order to establish whether or not he's the general contractor. He was addressing what employees there were on the job, and subs can have subs on a job. And if he comes in, Captiva's the organization that pulled the permits. Captiva's the one that put out the plans, and I think it's important that we address this. That Turning Point does contractor work, and sometimes assumes that role is valid, but in this case, on this matter specifically, they were not the general contractors pulling permits.
Well, I understand that there's a factual dispute about that, but we have to construe the dispute in favor of the non-moving party, which is the IVEYs, right?
You do, to the extent that you're looking at what the evidence the court looked at. The court looked at and heard oral argument, motion summary judgment, separate statement of facts, and made the conclusion that there was no contractual obligation that Turning Point had towards the IVEYs or any other obligation regarding CC&Rs or many of the allegations they're pointing to. If the court's argument is going to be that because Turning Point might have been a general contractor on this matter and so therefore has some liability further down the road, I think that needs to be analyzed. Those issues need to be analyzed separately.
Well, the trial court could not have resolved factual disputes on summary judgment, right?
Well, certainly they get to weigh the facts as presented before them and make decisions about whether or not testimony is credible or not.
So you're saying the trial court was entitled to weigh the evidence and make factual credibility determinations on summary judgment?
No, I'm sorry. On the extent to the support of the facts supporting the summary judgment, separate statement of facts, and the documentation supported given to the trial court, the court has the, I guess I'd say, discretion to take those affidavits and give them and analyze them and making their determination and applying the facts to the law.
I mean, you may be correct in the end that your client was not a general contractor, but from what Judge Kiley read in the record, there's certainly a dispute about whether your client was or was not. And it's my understanding of the summary judgment law is that the court can't resolve that if there's a dispute that's for a jury to figure out.
The courts, at the same time, the court has to look at the evidence that was presented before it, right? I mean, I'm not asking the court a question, but the court has to analyze what facts and information is supported by a statement of facts. And as I stated in, sorry.
When the court is deciding summary judgment, it's not trying to weigh credibility or figure out what the facts are. They're just trying to figure out, is there a genuine dispute of fact, is there a genuine dispute about what the facts are? And if there is, then summary judgment is not appropriate.
No, and I agree. And I guess the point I'm raising is the discussion we always have when it comes to some motions for summary judgment is that they can't simply rely upon their complaint. They can't simply rely upon their affidavits or allegations, that they got to produce something, some factual support to justify the rebuttal.
Well, that statement sure seems like factual support to me, whatever the ultimate outcome may be.
Well, and I guess to the court's question, I would point to the trial court and weighing the information before it and taking that under consideration when it enters its order in judgment. But I guess if I'm going back to my point, and I think this is exactly what we're discussing here, is to what role did Turning Point play in the issues brought up in the underlying complaint? To what extent does Turning Point, I'd make the argument not as a general contractor, Captiva is the one that's pulling permits, doing plans, they're the ones that are looking at easements and those sorts of things. Turning Point serves a role as coming in and carrying out those plans, putting in place the project that was crafted, designed by other individuals, not by Turning Point. And so to that degree, they don't have a responsibility towards the CC&Rs and many of the allegations brought by the appellants on this issue.
Well, you may be exactly right, but we're not at the fact determination stage at this point. But,
yeah, fair enough, yes. And I to the court, I mean, there was sufficient, there was information, there were facts, there was statement of facts and exhibits submitted to the court that the court used in making this determination as to what extent Turning Point was serving as a general contractor. And to the judge's point, in his testimony, I do think that he was responding more directly to the employees he had and the role that they're playing and his role overall in the overall case. But I don't see that there's documentation that was submitted to the court showing that he's a general contractor. We're just talking about the interpretation of a statement under questioning, and so I think that the way he's responding is to a different question altogether. And to that degree, I guess I go back and, which I guess is my second point, which is the nature of the summary judgment. The part I wanted to point out, and I do think this goes towards the court's questions, that this is often how motions for summary judgment are analyzed, right? Presented to the court. They're the statement of facts that support the motion for summary judgment, and oftentimes, I know as a practitioner, we talk to clients and they say, well, you know, how can people make allegations? And you say, well, people can make allegations, but at some point they got to demonstrate facts to support those allegations. And I didn't, in nothing that I read, did I see the appellants provide sufficient facts and support to the conversion claim or any of the other claims. And I'm looking at...
There's no dispute that the pavers were put on the IVEY's property, right?
There were.
So how does that not state a claim for trespass? How is that not sufficient to get to a jury on the trespass issue?
For Turning Point specifically, I don't think it does.
Well,
I think, go ahead, sorry.
Well, in the brief you said all Turning Point did was tell the subcontractor to lay pavers in accordance with the approved plans.
That's right.
Directing a third party to commit a trespass is also a trespass, isn't it?
But Turning Point is directing someone to carry out the construction labor for plans that they were given. It's not Turning Point who's, like I said, drawing these lines and getting the plans and laying out as a general contractor where this property line and pavers are going to go. They're carrying out a plan designed by somebody else. So that's why.
But they knew it was the IVEY's property. Mrs. IVEY told them that in pretty profane language, right?
There was discussions about it, but whether or not it's Turning Point, and I guess this comes back to the role of agency that it play. It's Captiva's job. Turning Point is serving really at the pleasure of Captiva. It's Captiva's project. And so if there's a dispute as to where a property line is, Turning Point is in their role capable of pointing up the chain of command and pointing at Captiva and saying, look, this is you pulled the plans, you got the surveys, you determine whether or not this is the right place for these papers to be. It's not, and I guess that goes to the heart of what we're arguing. It's not Turning Point who's doing the labor on this, on the long investigation, reading CCNRs and doing all the long legwork that it takes to actually get a plan in place for a house.
This seems to me to be a new issue. Is there evidence in the record that Turning Point didn't know that this was IVEY's property?
I don't know that, I can't answer that question. I can't tell you specifically when Turning Point understood that there was this problem in place. It happened early on in the process, but like I said, if it's permits have been pulled and lines have been drawn and Turning Point showing up at the job, I imagine they did show up and start immediately acting and performing the work, and there probably was a conversation right away. But whether or not Turning Point is responsible for the encroachment and conversion of the trespass or whatever analysis we're talking about, like I said, it goes up the chain to Captiva, who is the one who's making the big decisions on the project.
But your argument assumes or presumes that you are correct, that your client is not the general contractor. If, assuming counter to your argument, if they were the general contractor, were they reliable?
I think if they were the general contractor, I think we have we have to take a longer look to their liability, right? So if they are the ones who are, yes, if they're the general contractor pulling plans, doing all the work, talking to architects and actually drawing the line, then I think there's a conversation there. But it's different when they're a sub.
And that is what is in dispute. The IVEYs are saying that your client is a general contractor, and it has a statement in the record to that effect. You're arguing that no, your client is not the general contractor. The court can't resolve that dispute in summary judgment. That has to go to a jury, as I understand the law.
If the court is presented with permits naming a general contractor, if the court is presented with documentation that people submit to a government agency, a county agency for permit application that talks about who the general contractor is, I do think the court can rely upon that information. But we're looking at testimony, and like I said, I guess I'm splitting hairs on what he's actually testifying over, but we aren't looking at permits that were pulled that named him as a general contractor. We're talking Captiva's the one that did the big brain work, right? The one that planned out what was going to happen and where it was going to happen, and Turning Point carried it out.
And you want the court to make that factual finding rather than a jury when the IVEYs claim that your client is the general contractor. I mean, they may be wrong, and you may be right, but we don't know that yet.
But I guess that's where I was going back with the standard for motion for summary judgment. Orm School, I mean, it's not just, I pulled this up, right? It's according to Orm School versus Rees. Affidavits that contain inadmissible evidence that are internally inconsistent, that tend to contradict applicant's sworn testimony at deposition. Similar items of evidence may provide a scintilla or create the slightest doubt. We're not talking, I mean, it is a judge to sit down and look at an affidavit, the testimony, and to make a determination about whether or not this is a factually supported issue. It's not enough for a summary judgment, for a response to summary judgment to just point back to their affidavit and say, I believe this is to be true, without producing some sort of contradiction.
I'm looking at a permit that was attached to Cynthia IVEY's affidavit on summary judgment. It's permit number B1704-103. Lists various information. It identifies the owner. The owner name is Captiva Holdings 1, and the contractor is Turning Point. So at least this permit indicates that Turning Point is a contractor. It doesn't say general contractor, but it says contractor.
And then, I appreciate that. And so then we go up to I guess that my point would be, and the same argument I was making with Judge Howell here, is that then you have to look at what the actual role was of the contractor. What did they actually do in order to put this plan into place? And if Turning Point is simply acting on the behest of Captiva, who is the owner, and I'd argue the general contractor of this project, it's their property, their project, they get a point up. They get a point the finger at Captiva for doing the legwork of figuring this out, of drawing those lines. And if there's an issue, it's a Captiva that needs to litigate that and figure that out. It's not Turning Point whose obligation it is to take that issue to the court and straighten that out. All right, so I guess where I was going with that summary judgment, I feel like I addressed that. The court is looking at affidavits. It's not enough to simply point to an affidavit. We should actually point to some other documentation, something that would specifically allow the court to say this is the person that's responsible, not just a sworn statement of an affiant. I'm happy to walk through the other claims that were outlined. There are quite a few of them.
If I could just point you to the injunctive relief. My understanding of your argument is that an injunction can only be sort of negative. It can only restrict against or prevent the doing of something, as opposed to a mandatory injunction requiring, compelling some positive action. Do I understand your position correctly?
I don't like to always speak in absolutes to say it can only happen one way, but typically that is what's happening. An injunction is stopping bad behavior. I suppose that injunction could be crafted in a way that's going to compel positive behavior. But typically, I mean, at least in my experience and I'd say most cases, you are stopping somebody from doing something that is irreparable and cannot. So
if it can be the case that there's a mandatory positive injunction in some cases, then what is your legal argument against the injunctive relief claim?
That there's other ways to resolve that issue. That it's not just, we're not talking about property, we're talking about decorative rock, and I don't mean to minimize what we're talking about here because it is people's property, but we're not talking about something that cannot be repaired or replaced by money or compensated in some other way. We're talking about, I mean, that's the remedy that's here for injunctive relief, is that we can go back in time and fix these things if we need to. I haven't seen any argument or seen any evidence that supports that this is something particular or special that requires special consideration for damages or anything like that. It's a property and rock that was removed and papers put in place. I have 2 minutes left. If there's any other questions, I'd be happy to address them. But I feel like I plowed all the territory.
Thank you, Counsel. We appreciate your argument. Rebuttal? You have 7 minutes and 36 seconds. Don't think you always have to use all the time, but you're welcome to use as much time as you think is useful for us.
All right. I would just like to clear up the whole general contractor issue. You've brought it up, Judge Kiley. In the affidavit of Cynthia IVEY, she states in paragraph 7, Mr. Turner's ROC, Register of Contractors, number was listed on the City of Prescott building permit. And you identified the permit number, but the ROC number is the licensed contractor whose name was on this permit application. So to say, for Turning Point to say that, well, he was just talking about general, contractors having subcontractors is not the case. His ROC number was on it. The building permit lists Captiva Holdings 1 as the owner and Turning Point Homes and Development as the contractor. Those two together establish certainly a disputed fact, if not a fact that could be relied on entirely. How do you ignore that? It's not just some statement by Cynthia IVEY. That was on the permit. And then at the TRO hearing in January of 2019, he was asked about subcontractors, and he said, the question was, and you're responsible for those contractors as the general. as the general contractor? His response was yes, correct. I don't think there's even a dispute about that. So that issue, I believe, disposes of, was there a genuine issue of material fact in terms of that particular issue in the summary judgment proceedings. And I think it was error for the judge to assume that either my client's statement and the building permit and all the evidence concerning the general contractor, to ignore it and find in Turning Point's favor. So I think you've addressed this sufficiently, but counsel for Turning Point said that there's no documentation that Turning Point was a general contractor is simply not believable. And at the very least, it's an issue of fact. And furthermore, in the paragraph 16 of Cynthia Ivey's affidavit, she states, Mr. Turner continued construction of a house which he knew could not accommodate vehicle parking and could not comply with Land Development Code 9.5.9F setbacks without the use of a 10-foot portion of the easement on Lot 2. Lot 2 is my client's property, so they could not build this driveway without putting pavers down on my client's property, and he knew it. Mr. Turner knew this before it was installed. And that TRO hearing was before any pavers were put down, and if you read the actual testimony, at the very end, the judge said, be careful here, essentially, I'm paraphrasing, be careful, you may be asked to pull these pavers up or any concrete that you put down up for these reasons, and he did it anyway. So that's all the time I need. If you have any questions, I'd be glad to answer them.
No, thank you very much for your arguments today. We'll take the matter under advisement and we'll issue our decision in due course. Thank you. We stand adjourned.
Thank you.